Welcome back. I just got done doing a great little quick presentation to the Silicon Valley SCORE, a great group of business owners who are out there helping other business owners. They wanted to know what were some of the top mistakes employers make and what they could do to help their clients. So I only had about 20 minutes, so I apologize in advance for going through things as quickly as I did, but hopefully you'll learn a few things. Welcome to it. Thank you very much. I'm so excited to talk to SCORE. I'm excited about everything that you guys do. Rob Nuttleman, I'm an employment attorney, public speaker, and a mediator. Spend most of my days really just helping clients understand employment laws in California and how to navigate those. Today, we're going to talk about the biggest mistakes that employers make and how to avoid those things. So we're going to jump right into it because I know we're kind of pressed for a little bit of time. First issue that always comes up is employees or independent contractors. Many people still believe that a worker can be classified as an independent contractor. And they can, but only in very limited circumstances. In 2018, the California Supreme Court came up with a new test, and in 2020, the California legislature adopted that test as the default test. It's called the ABC test because you, as a hiring entity, have to prove all three factors in order for somebody to qualify as an independent contractor. One, they have to be free from control, pretty standard thing. They get both how they do the work and the performance of it, both in fact as well as what it says in the contract. They have to be performing work that's outside the usual course of the company's business, and they have to have their own independently established trade, business, etc. And that B part is the part where a lot of people fall into problems, because if they're doing work that you're in the business to perform, then chances are they are not an independent contractor. If they're an employee, that means a whole panoply of employment laws applies. There are a number of exceptions that the legislature put into place. The one that's most common that I see is the business to business exception. I always like to mention that because it is a viable option if the company or person you're hiring actually has an established business providing those services to other people. They may be an independent contractor. It does require certain things, such as if there's any required licenses, registrations, they have to have those. There has to be a written contract. And if they're providing the services to your customers, they have to do that in their name. So they shouldn't be showing up wearing your logos or your business cards. In fact, they should be introducing themselves as a subcontractor to your business. It's all set out in the statute. It's a nice, 12-page statute, makes it nice and convoluted. Bottom line is, before you think somebody is an independent contractor, pause, go through the analysis to make sure that that's actually correct. So let's say we've decided, okay, this is not going to be an independent contractor. It is going to be an employee. Well, what are the things that we want to have in place when we're going to hire somebody? Well, number one, we want to have some sort of a job description. Now, it might be simple as your job announcement. I like things to be a little bit more specific. What is the worker actually going to be doing? Are there physical requirements? Are there mental requirements? Are there certain skills, educational requirements? That job description is going to help in a lot of different factors to ensure that the people you're hiring and retaining are really able to do the job as you expect it. And so it's very clear, because what you can do in that initial interview is, this is the job description. Tell me about your experience handling these matters. It's a great introduction way for them to tell you what experiences they have. You can ask them, do you see any difficulty in performing any of the tasks that are listed in this job description? Hopefully they're going to say no. We want to have some type of an employment agreement. That could be as simple as an offer letter. It could be something more formal that is an actual agreement. It says it's an employment agreement. An offer letter is still an employment agreement, or you can call it a memorandum of understanding. You can write it on the back of a napkin as long as it has some essential parts that we want to see in that employment agreement. We want to talk about whatever the pay is, whatever the compensation is. Certainly, we want to have a statement about at will employment. At will employment is the standard in California. What it means is that the employer or the employee are free to end the employment relationship at any time, with or without any reason, and without notice. That is the standard, and that is even without a written contract, that is what the standard is. But we always want to make sure we specify that in the employment agreement so that it makes it more difficult for an employee to come back later and say, wait a minute, I thought this was my permanent job until I decide to retire. I do get a lot of companies when they want to fire somebody and they call me, we have the conversation, and they're like, well, I want to fire this person. I can just do it, right? Because it's at will. I don't have to give them a reason. Technically, yes. You can fire somebody for any reason as long as it's not an illegal reason. And there are so many different illegal reasons, whether it's based on protected characteristics such as age, race, sex, national origin, gender identity, gender expression, etc., or if it's based on some protected activity such as becoming injured on the job, reporting a workplace violence issue or workplace safety issue, some type of refusing to violate the law. There are so many of those exceptions that is really difficult to just rely solely on the at will employment because nobody ever gets fired for absolutely no reason. There actually is a reason. And I spend a lot of my time advising employers and employees on how to navigate those performance issues and discussion issues to hopefully maintain the employment relationship where we can. All employers are supposed to provide their employees with a labor code 2810.5 notice to employee. Essentially has a lot of the stuff that's going to be in the employment agreement usually. It is a form. You can download it from the labor commissioner. So if you do a search for labor commissioner, labor code 2810.5 notice to employee, you'll find it. It was updated somewhat recently. Some of the things you have to include is the name of the employer, the name of the employee, the location, the pay rate, your workers' compensation insurance information. If you have a single employee, you need to have workers' compensation insurance. So get that policy because that information has to be put into that Labor Code 2810.5 notice to employee. You also have to identify what your paid sick leave rules are. Every employer has to provide employees with paid sick leave as long as they've worked for the company for at least 30 days. So identifying the different methods or ways that you can have the paid sick leave. So it's important to have that, again, that check mark in that Labor Code 2810.5 notice to employee. That is something you give to the employee. Don't have to have them sign it, but there's a place for their signature, so why not have them sign it? Typically, also, you would have an employee fill out an I-9 and a W-4. The I-9 is confirming their authorization to work in the United States. The W-4 tells us how much we can take out in taxes. There's a new poster we have to give out to every employee or new notice called the Know Your Rights poster, which has a list of about 12 different laws that protect employee rights. That is something we have to give to every employee when they're hired, as well as every year by January 1 of each year. Other agreements to consider would be confidentiality agreements and possibly a mandatory arbitration or mediation agreement. I prefer to have confidentiality agreements and alternative dispute resolution agreements. If you're going to use them, have them separate from the employment agreement. If an employee breaches your confidentiality agreement, I'd like to be able to use the confidentiality agreement without having to bring in the employment agreement. And we always want to have the mediation and or arbitration agreement separate because that has to be a voluntary agreement. If we're requiring somebody to sign a confidentiality agreement and that has the alternative dispute resolution agreement in it, the employee really has no choice and it makes it more difficult to enforce that. The other big mistakes that I see is many employers believe that if I just pay somebody a salary, that means I don't have to pay them overtime. That is not the law. Most employees are entitled to overtime when they work more than 8 hours in a day or 40 hours in a week. Again, that is the standard. In order to be exempt from overtime, they have to meet one or more of various different exemptions. The most common of which are the professional, executive, and administrative exemption, all three of which require you to pay the employee a salary of at least 2 times minimum wage. 2026, that's about $71,000 a year. If you pay them less than that salary, they are not exempt, period. But just paying the salary is not enough. They also have to spend most of their time performing exempt duties. What are exempt duties? Those are the managerial duties. Or do they have discretion and independent judgment to make decisions about matters of consequence? Are they hiring and firing people? Are they making policies? Are they carrying out specialized projects? Do they have the ability to supervise 2 or more people? These are all different aspects of the different exemptions that might apply. The main point I want to get across to people is do not assume that paying an employee a salary means you don't have to pay overtime. It doesn't. In fact, it makes things worse. You're almost always better off paying an hourly rate than you are paying a salary. And what goes along with that, of course, is keeping an accurate record of hours worked. People who are not exempt from overtime, in other words, those who are entitled to overtime, we have to keep a record of the hours worked. Start time, break for lunch, come back from lunch, end time. It's really insufficient to just say I worked 7.5 hours. You want actually start time and end time. And those times should change. If somebody gives you a time card and it shows that they showed up every day at 8:30, took their lunch at 12 every day, came back at 1 and finished their day at 5, those are not accurate. I can guarantee it because nobody in the history of time has showed up to work always at exactly the same time and always leaves and has their lunch always at the same time. So I do recommend having some sort of a system where they can actually clock in and out, but at the very least, having some timesheets that they fill out. We do need to keep those records for at least 4 years after the employee stops working. So maintain those timesheets. If you don't want boxes and boxes of documents, scan the documents. It's fine to have electronic versions as well. Always make sure that employees get breaks. I mentioned that lunch break. The lunch breaks, we actually have to document. They have to show that they clocked out and performed no work for at least a 30-minute uninterrupted period. If we do not afford employees the opportunity to take their meal break or the rest break, then there's a 1 hour penalty that we have to pay. Almost every single demand letter that I've seen in the past 10 years from plaintiffs' lawyers includes a claim that the employee did not get rest or meal breaks. Even in situations where we've kept track of the rest and meal breaks, the claim is made. If we have the record, at least gives us the opportunity, the ability to defend that, because the law requires us to maintain the record of the meal breaks. If we didn't keep that record and the employee says they did not get their break, that's what the courts and the Labor Commission are going to go with. So maintain that accurate record of the hours worked. I mentioned everybody has to have paid sick leave, so I want to make sure we have our paid sick leave poster. If you don't have a separate policy, that should make its way into the employment agreement. Make sure you check your minimum wage. California minimum wage right now is $16.90 per hour. Certain industries have higher minimum wage, such as in healthcare industry, as well as fast food, as well as certain cities, San Jose, Palo Alto, San Francisco, Oakland, Emeryville, a whole bunch down south, and certain counties have higher minimum wages. So always check your local minimum wage where the work is being performed. It's not where the company is, it's where the work is being performed that matters. The other issue I see quite frequently is not failing to reimburse employees for use of personal devices. Their phones is a big one, or their cars. If they have to use their phone for work or use their car for work, we have to reimburse them for the pro rata share of that. So have a reasonable policy that pays the employee if they're using their phone, whether it's to log in and out or to check their emails, or maybe they're a salesperson and they're using solely their phone. I actually recommend oftentimes it may be better to actually give them a work phone that is only to be used for work. That way, when the employment ends, we can take that back and all the contacts that they made while working for you, you get those back as well. It's not stored necessarily on the employee's phone. There are certain benefits that we have to provide. We talked about paid sick leave a little bit. Even if you have one employee, you either have to provide a retirement plan or you have to register with CalSavers. CalSavers is a plan. I believe it's administered through the Employment Development Department, which allows employees to put money away into a retirement plan. Once you sign up for it, you have to notify CalSavers every time you hire a new employee. That new employee will get a message indicating that if they do not opt out, then a certain percentage of their wages will be withheld by the employer and sent to the state for retirement funds. Many people like that. Many people don't like it. If you use a payroll company, make sure you check with your payroll company to find out if they will handle the CalSavers administration for you. They probably won't sign up for CalSavers for you, but they may at least handle the administration. All employees have the right to opt out of that if they want. If people don't like the idea of the government deciding what their retirement plan is going to look like, they may or may not want to opt out. Keep in mind, certain cities have other benefits. San Francisco is a good one for throwing in benefits, including healthcare minimums that you have to pay, increasing paid family leave benefits or supplementing that. Typically, those only apply if the person is working 2 or more hours in the area in the city of San Francisco, and usually you have to have a certain number of employees. I think for the healthcare ordinance and the paid family leave, I believe it's 20 employees. They don't all have to work in San Francisco, but a total of 20 employees. So be sure to look at those local ordinances to see, are there other benefits we have to provide. Employers are typically not required to provide health insurance plans or health insurance benefits unless they have more than 50 full-time equivalent employees. So from most of our small employers, we don't have to worry about that for some time. But as we grow, we're going to have to have a plan in place. And in order to attract and oftentimes retain quality employees, having those health benefits, 401ks or other retirement plans, maybe short-term or long-term disability insurance plans, can be an economical way to bring people on where, as opposed to just being just a financial amount. I oftentimes get the question, do I need a handbook or do I need some sort of written policies? Well, I think it's always great to have policies in place. If you have 5 or more employees, you really I say, you should have an employee handbook. There are inexpensive ways to do that. I think the Cal Chamber has an excellent version. It is California specific. I prefer that over some of the handbooks that are created by national payroll services. Some of those are not necessarily California specific. What I like about Cal Chamber, it's got a nice wizard that you can go through, answer questions, and it will provide you a compliant handbook that includes city and county ordinance specific issues. Not all the language is exactly how I would do it, so I do like to modify that a little bit. But if you're just looking for an inexpensive way to get something on the books and get it out, that's probably the one I would recommend most. Obviously, working with an employment attorney or an outside HR consultant, if you're not big enough to have an internal HR, that's an excellent way to get that handbook in place. There are certain workplace posters that every employer needs to have. You've probably seen at certain workplaces, you go into the break room and you see that giant red, white, and blue laminated poster. And that contains a lot of the required posters, not all of them. The other problem with that big laminated poster is sometimes it will include things that don't apply to you. Many laws apply based on the number of employees you have. What are the magic numbers? One employee. If you have one employee, you have to have workers' comp and you cannot sexually harass your workers. At 5 employees, the anti-discrimination laws kick in, as well as certain accommodation and leave laws kick in. At 15, there's some additional leave laws, then 25, there's even more, and then 50 is the big number for getting into the health benefits. So really 1, 5, 15, 25, and 50 are those benchmarks where different or additional laws are going to apply to your organization. So that's why at 5, we really want to have an established handbook in place. And those laminated posters are going to be geared towards employer that maybe have 5 or even 50 employees, which may or may not apply to you. However, it certainly is a whole lot easier to go down to Office Depot or Amazon or many other organizations. You can get them from Cal Chamber and just get the posters so you can stick that up There are websites where you can find out individually what are the required posters. Most of those required posters do not include city or county specifics. Paid sick leave laws sometimes differ from county to county, and certainly the minimum wage laws, those are individual posters, as well as wage orders. Every company has one of 17 different wage orders that might apply to them. That wage order has to be posted. For most offices, it's wage order 4. If it's a place that provides food or like hotels, lodging, it's wage order 5. So, like I said, 17 different wage orders, making sure you have the right one posted. So I know that feels probably quite a lot like I just, turn on the water hose or fire extinguisher and shoved a lot of information down your throats very quickly. But I want to kind of go over what were the biggest mistakes that people have. You have my contact information. So if any of you need to reach out, I'd be happy to see what I can do to help. Thank you guys.